Welcome to the Mulcahy Law Firm podcast. For over 25 years, Mulcahy Law Firm has helped plan communities and condominium associations throughout the state of Arizona. Please go to iTunes or your favorite podcasting platform and leave us a rating and a review. Thank you for listening. Here's Beth Mulcahy.
Good morning, everybody, and welcome to class number 7 of our 2025 Virtual HOA and Condo Academy. I'd like to welcome everybody here today. And I know that there's a poll that just popped up on some of your screens. So if you wouldn't mind answering those 2 questions, that would be great while we're doing our introductory remarks. First, while everybody's joining, I'd like to just welcome everybody and give a few seconds for attendees to enter our Zoom and get settled for our class this morning. Welcome to class number 7 of our 2025 Virtual HOA Condo Academy. We teach this HOA Condo Academy in partnership with the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe. And we're very appreciative of the partnership that we have with these cities and are thankful that they want to provide free education regarding how to effectively and legally run HOAs, condominiums, and planned communities. Just some introductory remarks. My name is Beth Mulcahy, for those of you who haven't attended one of these presentations previously. I'm the founder and senior partner attorney at the Mulcahy Law Firm in Phoenix, Arizona. Our firm currently represents over 1,000 planned communities and condominiums in the state of Arizona. And I also currently serve on my HOA board and have for many years. I have been in the practice area of representing associations for over 28 years now. And I've dedicated my entire career to working with associations on their legal problems and helping them run their associations more effectively. I hope you're having a great summer, and I hope that you're finding ways to stay cool during this extreme heat. Things have been really busy on our end. Our team has been very hard at work putting together some new cheat sheets this summer, and we've also started releasing weekly blogs every Monday. If you're on our mailing list, you've probably seen them pop up in our firm's memo. If you're not getting our memo yet, please feel free to reach out to us at info@mulcahylawfirm.com, and we'd be happy to add you to our distribution list. We sent out 2 memos a week with helpful resources, class reminders, updates on new legislation, and the important updates on anything that may be happening in our industry that you need to be aware of. In today's class, we're going to first start out by talking a little bit about the Arizona legislature, which ended its session at the end of June, and the 4 bills that directly impact associations that you need to be aware of this year. All of these new bills, these 4 bills, are going to be taking effect on September 26th, so we'll be talking about them in July, August, and again in September to make sure that everybody feels comfortable with the changes in the law. We'll then dive into today our topic of the day, which is enforcement essentials and how to enforce your CC&Rs and other documents when you have issues with an owner not following your documents. We're going to discuss how to effectively handle violations, fines, lawsuits, rental issues, parking problems, delinquent assessments, and owners making unapproved property changes without getting architectural approval. As always, we will be answering questions at the end of our class. I promise I will answer every question before we sign off for the day. I'm going to try to conclude the main presentation right at noon, and we'll move right into the questions at that time. Due to the large volume of attendees, please note that there is a 1 question per attendee, limit. We appreciate you respecting our decision on that because it's hard enough to get through all the questions as it is. If you're joining us on Zoom, please submit your question in the Q&A box. And if you're joining us on Facebook Live, please type your question in the comments section and my office will get it to me so that I answer it during the presentation live. Okay, let's go to our poll. We have already gotten the results back. Thank you so much for those of you who responded. We had 99 responses, which is amazing. Thank you. Today, we have 1% from Avondale in terms of which city do you reside in, those of you who are here with us today. We have 15% from Chandler, 3% from Glendale, 3% from Goodyear, 25% from Mesa, 3% from Peoria, 20% from Phoenix, and 15% from Scottsdale, which is amazing to have, and also 9% from Surprise. Sorry, I almost missed Surprise. And Tempe, also 5% from Tempe. It's amazing that we have every single city that we teach these classes for represented today, so great job. Also, we had a question about what is your current role in your association or in our industry? So we have 65% of you are board members, 9% are managers, and 18% are interested homeowners, and 8% are just the other category. So really good representation of everybody in our industry with kind of more of a concentration of board members here with us today. So welcome, everybody. I will be tailoring the class today to make sure that I cover all these different aspects of those of you who have different roles in associations. Okay, let's start out by talking a little bit about the legislature. The Arizona legislature, as you know, opened its session in January 2025. They closed it the last week in June. As you may know, we're a seasonal legislature. So once the legislature is closed for the season, we won't be hearing from them again until January of 2026. There was kind of a lengthy budget battle at the end of the legislative session, which kind of took the last few weeks of the session, which sometimes does happen. It made the session go longer today, and they didn't ultimately end up closing the session until the 27th of June. During this session, Governor Hobbs signed 4 new bills into law that directly affect associations, HOAs, and condominiums. And those 4 new laws are going to go into effect on September 26, 2025. Let's talk a little bit about the 4 bills briefly. As we get closer to the effective date of September 26 of these new bills, we'll be talking in more depth, and we might even have a class that's focused pretty much on these bills and questions that may pertain to these bills. But here's just a quick little summary of what these new laws are. And again, they won't be going into effect until September 26, 2025. The first bill is Senate Bill 1039. And this bill pertains to HOA meetings and recordings. This bill requires that if a board records a meeting that is open to members, the board shall keep a copy of the recording for at least 6 months and make the unedited recording available to any member on request. And so basically, this is just an extension of the recording meetings bill. This and how I'm advising our clients is if your board is recording your board meetings, like let's say you're having your meetings on Zoom, which a lot of our clients are meeting. This bill is going to require that for any open board meeting, so this does not apply to executive session or closed session, the board's going to have to keep a record of the recording for at least 6 months and then make that unedited recording available to any member if they request it. So you'd have 10 business days upon request to provide that Zoom recording or whatever recording that you may have done of the open board meetings. Just a little extra onerous. If you are a board that's audio or videotaping your meetings, you do need to keep them. You can't edit the version of it. And if an owner requests to see it, you have to give it to them within 10 business days of the request. The next bill talks about political signage. This is Senate Bill 1378. And basically, this bill just changes the definition of a political sign to include a sign or a flag. So it's now adding those category of political flags to the requirements of the political sign laws that pertain to condominiums and planned communities in Arizona. It's kind of a gray area. And this really kind of started to go into effect with the presidential elections with the political signs. So it was kind of unclear. We were advising our clients prior to this law being passed, hey, treat a flag as a sign and allow it as long as it didn't contain any offensive language. And again, I think that this is the right call by the legislature to expand the political sign bill to also include flags. So there are some restrictions as to when political signs and flags can, be put up, and it would be before an election, time period before election, and taken down by a time period after the election. Okay, let's go to the third bill, which is Senate Bill 1494. And this talks about this bill applies only to planned communities. And this bill talks about when we can foreclose. So it makes it a little more difficult for us to foreclose as a planned community. And so basically, for the purposes of allowing foreclosure of an assessment lien, the minimum assessment delinquency that we have to have, or like the benchmark that we have to hit before we can foreclose, is now 18 months. So we can't foreclose until the assessment is 18 months past due, or the dollar amount that's owed is $10,000 in assessments only. And so any assessment or portion of the assessment is what they would consider. So it's going to be a little bit more difficult to foreclose if you are living in a planned community and we have a delinquency by an owner in a planned community. I think we're going to be leaning more towards once the assessment hasn't been paid for 18 months. So it would be any portion of the assessment unpaid for 18 months, and we can foreclose. So a little bit longer time period to wait, but I don't think it's going to significantly negatively impact the ability of planned communities or HOAs to foreclose. Okay, last bill applies only to condominiums, and it talks about it's House Bill 2322. And this bill addresses assessments on commercial versus residential structures in a condominium. Also included in this bill is a definition of a commercial structure, common expenses, and residential structure. So this is going to be talking more about like commercial structures versus residential structures. We're not going to see this come into play very often, but it's notable. And so wanted to just mention that today. Okay, so those are the four bills. We're going to be talking about these probably every time we hop online now until the effective date in September 26th of 2025. If you have any questions, please feel free to ask a question today or anytime in the future, and we'll be happy to answer those questions on the new legislation. Okay, let's switch gears and talk about our main topic for today, which is enforcement and violations and how to best handle this if you're operating as a board member or you're a manager, or maybe even you're a homeowner who has a neighbor who has, a bad tenant living in their property. We're going to talk about what are the remedies from A to Z, how to handle these situations, and give you some good advice as to stop banging your head on a concrete wall. We're going to give you some practical solutions to help you manage these violations. Okay, before we get started, we have a really great cheat sheet on enforcement of association governing documents. And we also have a cheat sheet on levying and collecting fines in a community, which we're going to be sharing with you. For those of you who may not be familiar with our cheat sheets, are a really great resource for anyone in our industry, whether you're a board member or manager or a homeowner. We have over 65 cheat sheets on different topics pertaining to association legal matters and practical matters of running an association. And you can find all of our cheat sheets on our webpage at mulcahylawfirm.com. We have given out hundreds of thousands of these cheat sheets over the years, and we have lots of clicks on it every week. They're a very valuable resource for board members, managers, and owners to find out a quick read on a topic pertaining to associations. Let's start out with our topic for today. One of the biggest problems that boards have, and I know because I've been serving on my board for 14 years, is what do we do when an owner is not complying with association's documents? Frankly, it's really kind of an annoying part of being on a board. I know that just on our board where I serve, we have a lot of problems right now with deferred maintenance, and we really need to be focusing our efforts on deferred maintenance. Yet we end up spending an inordinate amount of time hearing complaints from owners about violations or dealing with delinquency, the bad vacation rental in the association. And we lose time away from strategic planning and long-term planning on a lot of the deferred maintenance that we really need to be focusing on. And so one of my goals for today is let's simplify enforcement so that we get it set up kind of on autopilot so that it doesn't take a lot of our time and energy each month. And we just have processes in place that this is how this is going to be handled, and this is how we are going to address these type of violations, and then just do it. If you have a management company, guide the management company to take that next step at the meetings. If you don't have a management company, it's a little more difficult if you're self-managed, but if you don't have a management company, then you as a board are going to have to take the initiative on some of these violation issues. But we're going to give you the roadmap to help you. Okay, so what are some suggestions for how do we handle violations? If we've got somebody who's, let's say, made an architectural change without getting approval from the board or the association. So really the first thing that we're going to do is we're going to send a courtesy reminder letter to the owner. We don't want to be one of those big bad associations that's on the news for, being unreasonable. So we always start out on any violation, typically, unless it's a very serious health and safety violation. We typically will start out with just sending a courtesy reminder to the owner saying, the management company typically will send it, or if you're self-managed, the board will send it, just letting them know, hey, we're giving you notice that there's a violation here on your property, and we're giving you a time period to get it corrected. In most cases, this courtesy reminder letter just kind of handles the issue. The person gets the letter, they say, oh no, I'm sorry, I didn't realize that trash cans, couldn't be out on Tuesdays, or they couldn't be out Tuesday and Wednesday. They had to come in on Tuesday night, and the issue is resolved. But in some cases, we've got the owner that is habitual or they just blow off the first letter. In those cases, we typically will send a more formal violation letter after the courtesy reminder letter time period has expired. And either the board, the management company, or maybe even the association's attorney are going to send the more formal violation letter. We're probably going to be threatening fines. We're going to talk about fines in a minute, but we're probably going to be threatening fines in this letter. And we're also going to have some language in there that's required by law to include in the letter. And a couple of the things that have to be included would be you have the option to petition for an administrative hearing on this matter in the Arizona Department of Real Estate. I know that sounds strange that we as the association are giving the owner this information like, oh, if you want to petition for administrative hearing on this violation, here's the way to do it. But it's just that is what the law says. Also, we typically include in our formal violation letter language that indicates who saw the violation, what exactly the violation is a violation of in the documents, the date, time, and place of the violation, and a few other categories, because there is a kind of an obscure law that's out there that says that if an owner should request that information after receiving a violation letter by sending a certified letter to the association, then we're required to provide certain categories of information. What we typically do as a firm is we just put all that in the first letter so that even if they do request, by certified mail, we've already complied with it. So just kind of as a baseline, the formal violation letter is important because now things are getting serious. So the courtesy reminder letter is kind of the nicey nice letter. We're going now to the second letter, the formal violation letter, where we're saying, hey, we can fine you. And we're going to talk about the procedure to fine here in a minute. We talk about the required language that the state legislature has required us to put in the letters. And then our firm adds the additional language, which complies with another statute on violations, just to check that box in case the owner ever should request information by certified mail under that other statute. Okay, so formal violation letter is definitely setting the stage that we mean business, right? And this is serious, and there are going to be consequences if you don't comply. Okay, so let's talk a little bit about the consequences. So the first consequence is going to be we can fine an owner under Arizona law for violations of the CC&Rs, the bylaws, and the rules. And so we typically do include that in the formal violation letter that, hey, if you don't correct this violation by X date, the association will fine you. If you have a fine policy in place, maybe we need to have the fine policy listed there in terms of what their negative consequences if they don't correct it. So the key thing on fines is, there's a procedure that we have to follow. So I want to make sure that we're all on the same page. Sometimes clients will call me and they'll say, I want you to fine this owner $10,000 for not trimming their palm trees. Okay, that's not going to work. Here's why. Because the way the law is set up is that fines have to be reasonable. And so I have to be able to argue in front of a judge that, hey, this fine is reasonable, and $10,000 to failure to trim a palm tree is not going to be considered reasonable. Fine. Maybe $100 is going to be considered reasonable. And so the first thing on fines is the amount has to be reasonable. Then there's a whole procedure to set it up. We have to give the owner notice of the violation and an opportunity to be heard before we can levy the fine. So really, it's like a two-step process when you're threatening fines. You notify them of the violation. You let them know if the violation isn't corrected by X date, that this fine will be added to their account. We tell them in that first notification, if you want to object to this fine as your opportunity to be heard, please contact us in writing by X date. All of that's in the first letter, right? Then we have to do a little bit of waiting until that time period that we gave them to correct it, and then, or to respond to us. And then we send a second letter with the result of whether or not the fine is going to stand or not. And so there's things that can happen in between, like we send the violation letter with the threat of the fine, and maybe the owner cleans up the yard. If there's, it was a landscaping violation, maybe they clean it up and they write us an email saying, I'm sorry, I've had a health issue and I wasn't able to mow my lawn and trim my trees and pull the dead plants out of my front yard. But I've done it now, and here's a photo, and I'm please asking you not to fine me because I've complied with the documents. In that case, typically what the board will do is they'll just send a letter back saying, thank you for fixing this, and everybody moves on their merry way. Nobody gets fined. Let's give a different example of one where it doesn't work out that way. So let's say we send the violation letter, we threaten the fines in the violation letter, and the owner just blows us off. They don't fix it and they don't respond during the opportunity to be heard. Typically, that second letter is going to be a letter telling them that, okay, you are now fined and you haven't corrected the violation and you didn't come to the board with any sort of a written response as we gave you the opportunity to do. And now this is a fine letter. And also, here's some other things that we can do to pursue this violation. Sometimes, let's say, and let's give an example that's kind of a gray area. I'm just kind of not black and white. Let's do one that's kind of a gray area. Let's say that we send a violation letter to an owner. Maybe it's like an RV violation, right? Like they park their RV in the cul-de-sac all weekend, and there's no overnight parking of RVs allowed in your association. No overnight parking of RVs on your streets either, let's say. And so maybe what they do is they admit, yes, I did park my RV there and I'm sorry. I won't do it again, but I did park it there. And maybe the board's going to give them a small fine. Maybe they're not going to fine at all. I think it's really up to the board to listen to the owner and decide what is the best way to handle it. If you have a habitual offender, do not waive fines. Because if you're waiving fines on somebody who's a habitual offender, they will continue to do violations. Okay. I'm more in favor of waiving a fine on somebody if they ultimately do what they're supposed to do and they're apologetic. Typically, I'll advise the board to waive all or a portion of the fines just because we got what we wanted, right? We got them to comply. And now basically we just don't want them to do it again. And so we just have to listen to the homeowner and make the best decision that we can. Okay, so let's just talk real quickly. What's reasonable? It's kind of all in the eye of the beholder. Definitely reach out to your trusted advisors of your management company, your attorney, to get their input as to whatever the fine is that you're trying to charge. Is it reasonable? It's kind of like a sniff test. I can tell you right away if I think it's too much or too little or reasonable. What's considered notice and an opportunity to be heard that we have to give the owner prior to fining them. Really, I prefer giving them an opportunity to respond back in writing, and I give them the email where they're exactly supposed to send it versus inviting them to a meeting, because sometimes there's some scheduling difficulties on having them actually physically come to a meeting in person or by Zoom. So I really prefer having the in writing response, and that then both are okay in terms of opportunity to be heard. If you want to do a written one or you want to allow them to come to a meeting to talk to the board, you certainly have both options under that language. Okay, let's talk about how do we enforce fines? If we levy a bunch of fines against an owner, how do we actually get the owner to pay it? Well, it used to be really easy early in my career, back when I was still in my 20s. Now I'm in my mid 50s. But back in my 20s, we used to be able to lien a property for not paying the fines, which was a pretty incredible situation that associations could lien the property and then foreclose on the lien for fines. That went away probably in my 30s. And now the law has evolved to a point where, we can only collect fines from an owner legally by filing a lawsuit against the owner, getting a judgment against the owner for those fines, and then recording the judgment with the county recorder's office. And once we record that judgment, it becomes a judgment lien, and we can garnish the owner's bank accounts. We can garnish their employment, or when they sell their property sometime in the future, that lien will be paid, that judgment lien will be paid off. And so kind of the reality of this is we're not going to be going after collection of a fine if it's less than $500, really. So, for the people that just have small fines on their account, it's going to be, you're less apt to file a lawsuit, right? Because you're going to spend money in legal fees filing that lawsuit. So you don't want to spend $1,500 in legal fees to collect $500. That kind of doesn't make sense, right? So really the name of the game has kind of changed a little bit since the legislature made the requirement that associations can only enforce payment of the fines by filing a lawsuit, getting the judgment, and then recording the judgment. Typically, we're not filing a lawsuit unless the fines are somewhere between $750 and $1,000. So what do you do about fines that are just sitting on an owner's ledger and, the board hasn't gotten a judgment yet? I think kind of what most boards and management companies are doing is they're just leaving them on the ledger until maybe there might be an opportunity to add them to another lawsuit, like for unpaid assessments. So maybe the owner also owes $2,500 in unpaid assessments and we're filing a lawsuit. We're going to add a count to the lawsuit for the unpaid fines. That's something that I've definitely seen happen. Sometimes you just have them sit on the ledger and maybe when the owner goes to sell at some point in the future, the association just discloses, hey, these fines are on the ledger. And sometimes those fines are paid as part of the closing, even though there may not be a judgment against the owner for that. I'm not saying that that's perfectly legal. I'm just saying that's kind of what's happening in our industry. But if you have a savvy owner who understands that, like, hey, they can't collect these fines unless they have a judgment, they're going to be objecting to that at the close of escrow. Okay, so let's keep moving along and talk a little bit about what are some other options. So we've got the courtesy reminder letter, right? We've got the formal demand letter. We've got inside the formal demand letter where we can have the ability to threaten fines. We just went through the whole procedure on how to handle fines. Let's talk a little bit about self-help. What is self-help? Some association documents allow the association to correct a violation on a lot or unit owner's property and then charge them for the cost to correct it. So, for example, let's say that maybe an owner isn't maintaining their front yard and the association, provides notice. It has to be in your CC&Rs that you can do this. So they go to the CC&Rs, they see there's a section on self-help. It says they have to give maybe a week's notice, 48 hours notice prior to exercising self-help. And they do that notice, whatever it says in the notice requirements. It could be posted on the front door or you send it certified mail or whatever. And then we go in and clean it up and then we charge the owner for it. So in some cases, this is a really good remedy because it fixes the problem immediately, right? We're in control. We still have to collect it. We still have to be able to collect the money that we incurred in cleaning it up from that owner. And lots of times that happens when the owner sells. That money's on the account. We just get paid as part of the close of escrow. But self-help can be a really positive remedy in the right circumstance. One thing to think about, just remember, if you've got a dangerous owner, be really careful with self-help. We don't want to send the landscaper or painter or somebody in to fix a window if this person that owns property or is resident in the property is truly dangerous. So that's a consideration. If you're in that type of a situation, you want to bend over backwards to make sure that the owner is aware that we're using self-help and this is the day we'll be there between X time and X time. And I would also consider hiring like an off-duty security guard or police officer to help you through that situation. Have them right there and have them stay until the work is done. If you're truly worried about the person being dangerous. Let's talk a little bit about some other aspects of violations. So we have the self-help we talked about, we've got the fines, we've got the letters. Now let's talk about if this escalates to litigation. So, there's two different ways that we can go on this. You can go to Superior Court way, which is going to be the more serious remedy, or we can go to the state of Arizona, Department of Real Estate. So this is kind of like the offshoot if nothing's working so far. So you sent the letters, you've tried to find them, maybe you don't have self-help, let's say, in your documents, you can't do it. So now we've got to consider, hey, is this a good case to file a lawsuit on? It really depends. You have to talk with your trusted advisors, your attorney and your management company to determine what's the best way to get compliance. Sometimes before we file a lawsuit or we go the legal route, we pick up the phone and we try to reach out to the person that has a violation and really talk it through and just be like, hey, here's the deal. We've tried to contact you on these violations with several letters. We find you. There's no response. This is going to get expensive. Or our next step is to file a lawsuit, and this is going to be expensive. And sometimes if you talk it through with the owner under those terms and find out maybe some more information about why they're refusing to comply, we can avert having to go the lawsuit route. But let's say we can't. Let's say that the owner just is not complying after numerous requests. The fines aren't working, the phone call didn't work. We don't have self-help, let's say. So let's consider a lawsuit. Lawsuits are expensive. I'm going to say that again. Lawsuits are expensive. We should not be, as a knee-jerk reaction, filing lawsuits against everybody. sometimes litigation is the only alternative we have to get compliance. I know over the years I've had cases where, let's say maybe you have an owner who never finished construction on their property, right? And they never installed their landscaping. And the other neighbors are complaining because it visually is impacting their property value because this is unfinished house here. And everybody else, as their homes are finished, they're beautiful. One of them is trying to sell now. And everybody who walks in is like, what's the deal with that house? And so in that case, probably a lawsuit may be something that you may want to do. And the purpose of the lawsuit is going to be, hey, we're going to file a lawsuit in Superior Court and we're going to ask the judge to order you to do something. We're going to ask the judge to order the owner to finish the house, to paint the house, to clean up the landscaping. And this is a serious remedy because you're going to spend somewhere between like 3,000, 3,500. It could go as high as 40 or 50 grand in legal fees trying to get the owner to comply. And if they hire a lawyer on the other side, it could be more expensive because now they're going to want to litigate this and disagree about everything. So lawsuits can be good in that it's an attention getter. It's definitely threatening it is going to get their attention. Filing it is going to get their attention. When they're served with the lawsuit, that's going to get their attention. And I would say, maybe 75% of the time, things settle quickly once the lawsuit's filed. Like the owner realizes like, hey, this is getting expensive. I don't want to deal with this. I'm just going to do what I need to do. Percent of these cases, the owner is going to fight it or just ignore it. And then it just has to work its way through the process. And basically, most of these cases are not going to be the type of cases where we're going to be able to get a TRO, temporary restraining order. There's no irreparable harm if they don't paint their house, right? So it's going to have to work its way through the process. And we're ultimately going to have to, typically by motions, very few trials in my career on cases like this, because most of them are resolved through motions, like a motion for summary judgment. But litigation is a very effective tool for the owner that is very stubborn, doesn't want to fix whatever the violation is. It can be expensive. It can take up to 18 months to get a judge to rule in our favor. It could be shorter, could be a little longer too. And you're going to be spending money. Now, obviously, we're going to ask the judge for a judgment for our attorney's fees, including any fines that have been levied. But we're going to have to collect on that from the owner, right? So the judgment's just a piece of paper. We're still going to have to collect on that fine, and we're still going to have to get the owner to comply with what the judge orders, right? So I have kind of an interesting case that, this is kind of a long time ago. The question sometimes comes up, and I think this case is kind of instructional in terms of, okay, what happens if we go to court and we get the judge to give us a judgment saying so-and-so shall not park their limousine in a certain way. I'm kind of dating myself, right, with the limousine reference, because we don't really see those as much anymore. But many years ago, this is a case that was public record, so I think I can talk about it pretty easily. Many years ago, I was involved in a case on behalf of an association, and a gentleman owned a limousine, and he would park it every night when he got home in such a way that the limousine, it didn't fit in his driveway. So the front half of the limousine was in the driveway, maybe even like half of the door where the people would be getting into the limousine was in the sidewalk area. And then the back of the limousine was extending actually into the street. And we had to file a lawsuit against this owner to get him to stop doing this. And anyways, we got the judgment against the owner. And basically the judge ordered the owner stop parking the limousine in this fashion. And so unfortunately, the owner continued to park the limousine in this fashion. So this is a really good example of, okay, what happens when a judge says, stop doing something, and it's a judgment, and it's, a mandatory permanent injunction compelling the owner to stop doing something. And in this case, the owner was like, I'm going to keep doing it. We had video evidence, photographic evidence, etc. So what do? We go back to the court and we file a motion, and we ask the judge to hold the owner in contempt of court. And, in this particular case, this was kind of a really unique factual pattern, but it's notable. I just remember it like it was yesterday. So this was back when we were going to hearings in person before the pandemic. And I'm at the hearing and we're asking for the judge to hold him in contempt because he was violating the injunction. and he didn't show up. So I'm just there. The judge's there. I'm there. Bailiff's there. And I'm explaining to the judge, I've got the pictures, I've got the witness with me to give testimony. And before we know it, the limo driver owner, blows into the courtroom, sweating and throwing papers everywhere and slamming his thing down on the table. And that's really not a good way to come into court on its own. But then the next thing we knew was there was a police officer running after the owner and coming into the courtroom too. And the judge is like, whoa, what's going on here? Everybody stop. And the police officer said that the owner limo driver had just illegally parked the limo in the no parking zone in front of the courthouse. And then so honestly, it's hard not to laugh when something like that happens because it was just so ironic because he's doing the exact same thing at our association. That's why we're there for the hearing. And the judge called the bailiff over right away and was like, put this guy in handcuffs. Like, you're going back. This is not working for me. So there are consequences. That story is like a really good example of, okay, there are consequences. If the judge orders the owner to do something, they don't do it. You ask for a motion for contempt. In that case, I think it really did help that he was double parked in front of the courthouse. And I'm kind of laughing. I think at the time I was leaving the courthouse after the hearing, and it was flip phones back then. We didn't have as many, easy to take selfies, but that would have been a really good selfie, right? Coming out of the courthouse and seeing that car getting towed, the limo getting towed. Anyway, so to close the loop on this, there are definite penalties if an owner doesn't comply with the judge's order compelling them to do that. I haven't seen that come into play very many times, like maybe 10 times in my 28-year career, but it's something that does happen. Also, any attorney's fees that we incur are typically going to be awarded as long as the judge finds them to be reasonable. So in addition to the judge ordering the owner to stop doing this, there's also going to be an attorney's fees award typically, and then also the costs that have been incurred to file the lawsuit. So very expensive and serious consequences for owners if they don't comply. Now, we're not typically going to, file a lawsuit on somebody who's not putting their trash can away. It's going to be the more serious violations. Okay, another possible remedy that we have for violations is to go to the ADRE. And this is the State of Arizona Department of Real Estate. And our office is going to be sharing the website for this particular program. And basically, the ADRE was set up maybe now like about a decade ago as part of one arm of the Arizona Department of Real Estate is that they hear disputes between owners and associations or associations and owners, but they have to be pertaining to state law, pertaining to associations like the Planned Communities Act or the Condominium Act or the association's documents. So this is not someplace where the management company can be sued. This is between association and owner, okay? Basically, what happens is one of these parties, either the owner or the association, files a complaint with the ADRE. They have to pay a $500 filing fee for each question that they want the ADRE to hear. And once they file the complaint, then the association we're typically not the one filing, we're typically the one on the receiving end. We have to file a response to the complaint, and then there's a hearing set. Now, there are some benefits of going to the ADRE. The administrative law judges in Arizona hear these ADRE complaints between owners and associations, and we typically get the hearings pretty quickly. So let's say that somebody files for a hearing on June 1st. You're probably going to have that hearing sometime in August, early September. So that's really fast. Like in litigation on the other side, like if you're filing a lawsuit in Superior Court, it's going to be hard to get a hearing in front of a judge unless there's irreparable harm and you're asking for a TRO, a temporary restraining order. So ADRE, one benefit is it's cheap, $500. You're not entitled to your attorney's fees, either side. So you won't be getting your attorney's fees awarded by the ADRE. So you're going to file a filing fee. You typically, as the association, you are probably going to have your attorney representing in this. So you're going to be paying out of pocket your attorney and not be able to recover it against the owner. That's a drawback. But one of the benefits is that these cases are heard pretty quickly. And the judges that hear these cases are very bright, just like Superior Court. So you're going to get a fair shake. They understand our practice area and they do a really good job. And so this is basically like a little mini trial at the hearing. And in our experience, this has been a very beneficial venue for associations to have disputes with owners resolved quickly, efficiently, and by not spending a lot of money. And I encourage you to check out the website. I think right now we probably have 3 or 4 of these cases pending on behalf of clients in the ADRE, and it's about how much we have every quarter. There's always about 2, 3, 4. And like I said, our experience has always been positive. Also, same experience with Superior Court, very positive experience in terms of, the quality of the judges that are hearing these cases, and they understand the issues in HOA and condo law. And they usually 99% of the time will come to the right decision. Okay, let's talk about what are some common violations that we see for our last 15 minutes of this class today. So we typically will see violations with rental properties. And that's a very common complaint that we get from clients. Hey, we've got a bad renter, or they're violating our short-term rental policy, or there's a long-term renter in here that's doing crazy things at the pool or parties all the time. And I think we all can agree that there's been a pretty dramatic increase in the number of rentals in Arizona, really in the past decade, especially with the advent of the short-term rental companies like VRBO and Airbnb renting properties on a transient nightly basis in many of our communities. We have a great cheat sheet on working with rental properties in Arizona, so I'm going to encourage that you take a look at that. We're going to be sharing that with you right now during the presentation, or you can find it on our website at mulcahylawfirm.com under the cheat sheets tab. Let's talk a little bit about what is current Arizona law regarding rental properties. So a couple things that you need to be aware of. Well, number one, if you're having a problem with a renter, check with your city, town, or municipality, because a lot of these cities, towns, and municipalities have procedures in place regarding short-term and long-term rentals. And so you maybe want to make sure, check with the code enforcement department, see if they're violating any of the specific code requirements that your city has. I know that like City of Scottsdale and Glendale and Chandler, they all have pretty advanced programs internally to best manage, and Tempe to best manage problems with renters and bad landlords. So definitely keep that in your back pocket. That's kind of an expensive way. Maybe they can, if there's a code violation going on, maybe you can have the code enforcement department help you get rid of that complaint that may be happening in your association. In terms of associations, what are our rights when an owner wants to rent a property? I mean, look to your association. Does it say anything about, is there a minimum time rental that they have to comply with? Is there no minimum time rentals? That means they can rent property nightly. So definitely as a starting point, look at your association's documents. What does it say about rentals? If it doesn't say anything about rentals, that means rentals are allowed. If it has a minimum rental period of 30-day minimum, that's enforceable, and you as board definitely can enforce that. A couple of pointers on rental properties. An owner can designate a third party to be their designated agent for that property. And so I don't see this very often, but it's notable because occasionally an owner will appoint a tenant to be their agent for the property. And, then the tenant can come to board meetings and talk. The tenant cannot vote as an owner, but they have rights to talk at board meetings and at the annual meeting. Sometimes the owner landlord will designate a management company who manages their rental properties to be their agent. In that case, we can communicate with the agent as their designated agent if it's in writing. And again, to be the designated agent for a property, the owner landlord would have to put it in writing and tell the board, this is, who my designated agent is, and you're allowed to provide them with the payoff, let them speak at meetings, whatever. Okay, what can we ask the owner who's renting their property? What can we ask them regarding their tenant? So Arizona law is really strict about what we can require them to provide to us. So we cannot require them to provide the, landlord-tenant agreement, the lease agreement. We can't. What we can require them to provide us is the name and contact number of any adults that are going to be occupying the unit or lot, how long the lease is going to be, including the beginning and ending dates of the tenancy, a description of the license plate numbers of the tenant's vehicles. And that's it. So that's really kind of a limited amount of things we can ask for. If you're a 55 and over community, we can also ask for proof of identity that at least one resident who's renting is going to be age 55 or over. So that we are making sure that we don't lose our over 55 status based upon a rental that's going into your association. So very limited things we can ask for. We cannot, again, ask for the lease. We cannot ask for criminal background check on the tenant. We can, after we send them a notice asking them for this information, meaning asking the landlord owner for this information, we can charge them $25 for kind of like a processing fee, so to speak, within 15 days after we request the information from the owner. So we can charge them $25 for each change in tenancy. If it's somebody that is carrying their tenancy over, like they just leased for a year and now they're going to lease for another year, we can't charge 25 again. We only can charge the one-time 25 at the beginning of the tenancy, even if there's a renewal. If they don't provide that information to you within 15 days after our postmarked request, we can charge them an additional $15 for not complying with that request. And really, it's a very minimal amount of money that we can charge. A very typical question that I get is, well, can we fine them for not giving us the information that they're required to give us under the law? We can only charge the $25 after asking them for the information and waiting 15 days. And then the $15, if they don't provide it to us, that's it. We can't fine them an additional amount on top of that. So that's kind of important to note. I think really that's it in terms of the rentals. I think I want to talk from a practical standpoint. Like, what do we do if we have a bad tenant? Like, how do we handle that? That's an enforcement matter that needs to be discussed. So I have lots of examples of this, of bad tenants. Maybe the tenant's having wild parties. Maybe the tenant is parking in a way that's violating the documents. Maybe the tenant's not maintaining the property. I mean, I've had situations where we've got the tenant bathing in the pool. There's all kinds of interesting stories regarding tenants over the years, and equal number of good stories about tenants being great neighbors too, by the way. So what's the best way to handle a bad tenant? I fine-tuned this over the years. I think this is really some very great advice that I'm giving you right now. The best way to deal with the bad tenant is to make it hurt in the pocketbook of the owner or landlord. How do we do that? We fine the owner for the behavior of the tenant. Okay, so we document everything very carefully with photographs or information about when the tenant is violating the documents. And the owner is ultimately responsible for the behavior of the tenant. And so if it's truly a bad tenant, this is going to start to multiply, right? There's going to be fines on the property and lots of complaints. And I've even had tenants where a SWAT team's coming in to DEA is coming in to SWAT team the property and take people away in handcuffs and paddy wagons. And so this is what we typically will do in situations where there's a really bad tenant. We're going to be fining the owner for the bad behavior of the tenant, number one. Number two, we're going to have our firm contact the owner. And typically this is kind of how it usually goes with the owner. I tell them, hi, my name's Beth Mulcahy. I'm the association's attorney. We've been reaching out to you regarding your tenant and the violations on the property, and maybe give a quick little elevator speech on this is what the property violations are. And typically the landlord isn't saying too much. And then after I finish, they'll say, the association's just being nitpicky, and the tenant tells me they've got this cleaned up, and the SWAT team was actually their friends pranking them, or whatever that story is. And I usually say at that point, are you at your computer? And typically they say yes. And I say, can I send you some information? And then I'll send them the police reports, the photographs, all the pictures of the beer cans and the liquor bottles on the front lawn, and images of somebody showering at the pool, or whatever the issue is. And that's evidence that's like right in front of them. And I say, here's the deal. Here's the evidence. We're not backing down on this. This is going to get very expensive for you. We're going to continue to fine you. We're going to file a lawsuit in Superior Court. You're going to be responsible for the attorney's fees, the fines, and ultimately this tenant is going to end up costing you way more than you're getting in rental income. And at a certain point, after hearing all that, the landlord typically flips. I mean, I can't think of one call where the landlord hasn't flipped. And then they start to say, how do I get rid of the tenant? Can you help me evict the tenant? And so that's the way, that is the path to get the landlord to comply. We have to show them with evidence that, hey, this tenant is violating the documents. It's obvious, and we're going to fine you, and we're going to go to Superior Court and get a lawsuit going and get a judgment against you, and you're going to be responsible for our attorney's fees. And this is ultimately going to cost you a lot of money. And that, to me, is typically the combination that is going to get the landlord to comply and get the tenant evicted. It takes a little while to do that. Typically, they have to follow their eviction process, but we're a partner with them, providing evidence. If we have to go testify, I've testified before in situations like that. One other thing I want to mention is that if a landlord knows that there's criminal activity going on in a property and they don't abate it, they can be held liable in criminal court for that. So I've only used that one time. I've threatened it before, but I've only used it one time where the landlord actually was convicted of criminal charges because the landlord didn't do more on their tenant. He knew that there was criminal activity going on, and and ultimately that ended up being a drive-by shooting. And the landlord owner was held criminally responsible for the behavior of it. So that's always a good thing to keep in your back pocket to mention to them. Okay, let's talk a little bit about parking. We're just kind of winding down here in our last few minutes, but parking can be an issue. That's a violation that we hear about a lot. The most common parking violations are going to be, hey, they're overnight on-street parking, or maybe illegally parking RVs, campers, boats, trailers, or maybe they're parking in the driveways and you're not allowed to park in the driveway, or maybe they have 8 cars and they only have space for 5 or whatever. So what's the best way to handle parking violations? Check your documents. What does it say about parking? Make sure that it is actually a violation. Another question is, who's going to document all these parking violations? Typically, it's the neighbors, because they're the ones that are upset about this looking like a parking lot. But sometimes an association has like an overnight parking monitor that comes through and takes photos. What are some things that you can do? Obviously the normal remedies: first violation letter, formal violation letter, fines, but you also can try and meet with the resident, pick up the phone, call the resident, find out what's going on. Maybe they've got a wayward kid that's home for a month and they're going to be gone a month, or that car will be gone then. Some things that we can do: you got to check your documents. Can we tow? It needs to be in your documents. Maybe that's an option, but it has to be in your documents again. Put sticky stickers on the driver's window regarding the violation. Wheel boots, similar devices are used by association filing a lawsuit, injunctive relief lawsuit, kind of like our limo driver that we talked about. And then also maybe consider going to the A and having a complaint filed against the owner. Another typical violation, just switching gears for real quickly here in kind of the last few minutes of our class, is going to be, what about unauthorized alterations to property? This is another very common violation. Goes and does something to their property. They never got architectural approval. Pretty common thing that happens. That maybe they paint their house a new color, they change their landscaping, they feet gate, they put in a concrete pad for their new golf cart. These are all examples of architecture. First, check the documents to make sure that the owner, whatever they did require architectural approval, would be number one. Typically, the best way to handle it is to informally contact the owner or send them a letter, a courtesy violation letter, and ask them to submit an application for this. And then we have to look at the submission when it comes in. If they refuse to submit it, that's probably going to be another phone call asking them what's going on. If they submit the application and it's something that you would never, ever approve, talk with your attorney about what's the best way to handle it. Maybe at that point I need to get involved, and maybe we need to send a letter demanding that they return it to its original condition. A common question that we get is, do we have to, as a board, approve this just because the owner already did it? And the answer is no, you don't. Does it make it more difficult to get them to reverse it? Of course it does. But ultimately, from a legal standpoint, the association is in a very strong position in that they didn't get approval, the homeowner didn't get approval, and they needed to get approval. So a judge could require them to return it to its original condition. Okay, let's just spend 1 minute on our last subject before we enter the questions. What about violations that are collection of delinquent assessments? So we're starting to see an uptick right now in owners not paying assessments to associations. During the pandemic, it was an incredibly high number of owners that were paying their assessments on time, which is great. But we're starting to see a little bit of a reversal of that. We're starting to see somewhere between 5 and 8% of owners in each association are now not paying assessments again. And so our best advice to you, if you're in this type of an enforcement situation for your association, is get on this debt early. Be proactive in collecting delinquent assessments. Do not wait to give it to me as your attorney when it's $5,000 owed. No. Set a benchmark for your association and then follow it so it's on autopilot. Okay. Once the owner owes $500 in assessments, we're going to have the management company lien. We're going to send it to the attorney for them to take legal action. Getting on these early versus waiting later, you'll get them resolved a lot faster. It's easier to write a check for $500 versus $5,000 for an owner. And just being proactive and the owners knowing like, hey, if this gets to a certain point, we're going to charge late fees. And if this gets to a certain point, it's going to go to the attorney. And if this goes past the attorney, then there's going to be a foreclosure or there's going to be a personal judgment lawsuit that we file. And so all of these things are important. Just be on top of the delinquencies now as we're starting to see this shift from owners not paying like clockwork, like many of them did in Superior Court. A couple things that you need to know when a file is turned over to our office, we do due diligence upfront. We do a full 360 credit review of the owner to determine what is going to be the best way to get this owner to pay. So are they employed? What's their debt to credit ratio on the property? Do they have a bunch of credit card debt? Do they have other judgments against them? Are they habitual? Have they been here before? Are they a bankruptcy filing risk? And then we report back to the board, this is how I think we can get the money for you. And I think that's a really smart thing to do at the outset, because sometimes I'll look at a file and I'll see, and I'm looking at it and I'm like, oh, this is like train wreck. This person is not going to be collectible because they're teetering on bankruptcy. They've got judgments against them by multiple parties. They're underwater on the property. And then on the flip side, sometimes we look at it and we're like, okay, they're employed. They got a little credit card debt, but no judgments. This is one we can pursue. And this is the path that I think we should do. So just to close the loop on unpaid assessments, if you're starting to see an uptick in unpaid assessments like we are, we're getting more files turned over to our firm right now from associations who have owners who aren't paying assessments in a timely manner. Get on top of the debt early. Do not let it sit there. It's a bad message to the owners and it makes it harder to collect if you let it sit there. Okay, we also have a great cheat sheet on collecting assessments, that secrets to collecting assessments that are on our webpage at mulcahylawfirm.com, or I'm sure we're going to be sharing them with you during this presentation here today. Okay, 12:03, I'm 3 minutes over. Sorry about that. We're going to go into questions now. Let me just do a quick question check. How many questions we have? Oh, we've got a lot of questions, 36 questions. So we will jump right into the questions. This first question is a question that we hear all the time. So we're going to start with this one. It's from one of my favorite managers. How would you approach a board who does not want to take any action other than placing a lien for the non-payment of assessments? They were burnt in court by a judge ruling in favor of the homeowner, so now they don't want to do anything. They don't want to take any actions. Won't they have the inability to collect assessments after a certain period? So short answer is yes, 6 years. We have a 6-year statute of limitations to collect the debt. If you have a cheat sheet on this subject, I would appreciate sharing. Any information would be to my benefit. So I would send this to this particular person. I would send the cheat sheet on the secrets of collecting assessments. And I would just say that, yes, there are times where the judge may burn the association and maybe not give us all of our attorney's fees, or occasionally an owner will win if the association somehow made a mistake on their ledger or something. But 95% of the time, if you file a lawsuit against the owner, you're going to get the judge to order the full amount that's owed. And the owner is going to have to pay it plus reasonable attorney's fees. So I think the approach of just liening the property, people get word of that and they're just going to not pay because they know the only consequence is that, hey, there's just going to be a lien on my property. So I do think that you should be pursuing the files that have, when we do that credit review and we come back to you and we say, hey, this person is collectible, those are the ones I think you should be pursuing. Okay, next question, number 2. We recently purchased a townhouse condo in Prescott and lived there during the summers. The builder is still managing the HOA association, and according to the CC&Rs, does not need to turn over the management of the HOA to the residents until he's completed the remaining 4 structures in progress. He's been a great builder and he's done nothing we think is suspicious, but we have not seen any financials as to the health of the association or the size of the reserve fund. Can we see current financials? And is he required to distribute this information to residents annually? If so, how do you suggest we approach him gently about seeing them? Great question. So, as a reminder, every association, even when under developer control, should be having an annual meeting every year. And that would be a great time for the developer to update the board, and the developers might be the board still at that point, but to update the residents. This is what our financial situation looks like. Here are our problems. Here's our solutions, type of thing. So encourage the developer control board to have an annual meeting because owners want to hear more information about the association. Secondly, you can make a records request to see the current financials, the year-to-date budget, and the reserve account balance and the reserve study. All you need to do is just put that in writing, remind the developer that they have 10 business days under the law to provide it to you. Okay, we also have a good cheat sheet on checklists from developer to homeowner control on our website that I would encourage you to take a peek at. Okay, question number 3. Is it okay to send courtesy notices and citations in the mail? And do they need to have signature or send them by certified mail? If they do not pay, what is our next step? So I would recommend that you send any notices to owners regarding delinquencies or violations by U.S. mail. I would not send it by certified mail unless you're required to under the law on something. Why? Because most owners who are delinquent or who have violations never bother to pick up the certified mail. So then they'll try to say, oh, I didn't get it, type of thing. So we typically send everything regular mail unless we're required by some particular circumstances to send it by certified mail. Let's see. If they do not pay, what is our next step? So take a peek at our cheat sheet, Secrets to Collecting Assessments. So if an owner doesn't pay, I would lien and then send it to the attorney to do an evaluation if you should do a foreclosure or if you should do a justice court judgment action against the owner. Okay, question number 4, regarding whether Arizona HOAs can prohibit group homes. Does this pertain to single-family homes with multiple generations living in that house? Great question. So when you have a multi-generation family living in the house, like grandma, parents, kids, grandkids, that's considered a single family under Arizona law and under the laws of most of your cities. It seems odd because there's probably a lot of people under one roof, but it is still considered single family. Okay, the next question, number 5. We have a hazardous tree leaning toward the house. It could potentially fall onto the house and cause personal injury that would be life-threatening. There is a work order for cutting the tree that is 4 months old. We've made many requests discussed during board meetings. The board has not taken any action in over 3.5 months. What is the liability to the association and the board if there is a personal injury and the co-owner sues the association and the board? So I don't know if the tree is an association tree. So that would be a fact that would be important for me to know, like, is it located on the property? If it is, I'm very concerned. The board needs to handle this like pronto. If it's on another owner's property, it's an owner's tree and it's leaning toward another owner's house or that owner's house, there's less urgency. I mean, obviously more of it's taken care of, but it's not like we're going to be held liable if the tree falls. Obviously, I would continue to contact the owner. Self-help should be considered. Like, the association's attorney needs to get dialed in on this right away and start sending letters. Question 6. In your firm's cheat sheet, the board director removal process, the last sentence states, finally, it is important to remember that if the board receives a valid petition for removal, but the board fails to call, notice, and hold a special meeting within 30 days after such receipt, the board member subject to the petition will be deemed to have been removed from office effective at midnight of the 31st day. What is throwing me off is the verbiage office. My question is, if we don't hold a meeting, the director can be removed from the board without voting. Our CCNR says the director can be removed from their officer position by the board, but a director can only be removed from the board as a director by a vote of the community, and they were voted on. Therefore, they are voted off the board. Okay, so the question is, if we don't have this special meeting after we get the removal petition, can that director really be removed from the board without voting? So the answer is yes. State law says that if the board doesn't have the removal meeting, they don't notice it, they don't hold it within 30 days after the receipt of the petition for the removal, the board members who are subject to the petition are deemed to have been removed. So at midnight on the 31st day. So even though your documents say another thing, state law trumps your documents. And we have a great cheat sheet on the board member removal process. I encourage you to take a look at it. Okay, question number 7. What are the legal requirements or best practice for allowing homeowners to contact a board member directly? We have a management company that provides a portal, a number for our property managers, an emergency number, and an email address. I mean, typically what happens is if the association is managed by a management company, all communications for the board go through the management company. That's just kind of how it works. If you're not managed by a management company, then the board should give out a contact information for in the event of emergency, here's how you contact somebody. So what are the legal requirements? There really aren't any legal requirements that are under Arizona law, but the best practice would be have a place that is easy to find, like on your association's website, letting people know where to go when an emergency arises. How do they contact the person? What's the best way to handle it? Question 8, our master association is raising their fines for violations from $25, $50, and $100 to $250, $450, and $550. In my opinion, this is an excessive increase. Are the allowable increases controlled by state statute or other laws? So no, they are not. And honestly, I mean, it does seem a little high, but I would have to read it. I think it's probably defensible, even though it starts at $250. Okay, let's see number 9. Is there a law which prohibits or any reason preventing homeowners from gathering signatures on a recall petition in advance of a condo board election? I think that you can only, I suppose if the petition isn't dated, you probably can get away with it, but I think it would be best to start the petition once the members are seated on the board and are actually board members. Question 10, what's your advice on how to deal with a rogue board member who continues to harass our management company employees? Unfortunately, I know firsthand all about this in many different ways. So we've got a great blog that we sent out yesterday on HOA condo board infighting. Another option would be to contact us for a boot camp. When you have those rogue board members, you really do need to nip it in the bud. And one good way to do it is to have me come in as a facilitator. I already know that there's a problem. I know the board member, I know what the board member is doing. And in a very direct way, we talk about the issues in a boot camp and we resolve the issue before we leave the room. Another option when you're dealing with a rogue board member, I know I'm dealing with this, unfortunately, with one of my associations that I'm a board member for, is the rest of the people on the board need to stand up to the board member that is bullying the management company and say, enough, no more. This is not acceptable behavior for a board member to be treating our manager in this way. And everybody stands behind and agrees, stop it. And that's a very good way to do it. Now, what we typically see is everybody sits back because they don't want the conflict. And maybe they say to each other, like, oh, I don't like it when she does that, or makes me uncomfortable, but they never actually say to the person, stop doing it. That is the only way to get them to stop. And maybe people don't like that type of confrontation, that maybe you have me come in and do it in a boot camp so that we address the issue. One just kind of parting comment, my office wrote this on the questions. I agree. Dysfunctional boards seem to be a theme this summer. We're seeing a lot of problems with boards not getting along, a lot of problems with high level of dysfunction. So really, if you're out there and you're struggling as a board, now is the time to think about setting up a boot camp where we come in and help you try to solve that dysfunction. And typically August is a quieter month, so it's a great time to work on something like that. We could set it up all by Zoom, and it could be a really effective tool to help you go into the last quarter and a half of this year with getting rid of that dysfunction. Okay, next question, number 11. Is there any means by which either the board or the community can impose an education requirement to serve on the board? It would have to be in the bylaws if you're going to do that. A requirement would have to be in the bylaws if you're going to do that. Okay, question number 12. How or can we limit the number of group homes in the community? So we have a great cheat sheet on federal laws that talks about group homes and the fact that they are protected under the Fair Housing Act and can't prohibit them in an association. And the associations really can't limit, meaning like we couldn't pass a CCNR amendment saying only 2 group homes are allowed. But what you could do is check with your city, town, or municipality. They have limitations in terms of how many group homes there can be in a certain square mile. So you may want to check into that. Question 13, how long does the HOA have to respond to an appeal request? Check your documents. I don't know, there might be something in your documents on this, but I would respond promptly, like within a week would be what I would suggest. Question, or respond to them that, hey, we're having a meeting on August 15th and we'll be discussing it then, so they're aware of what's going on. Question 14, can an HOA use funds from the operating to pay for a capital project and not the reserve fund? That'd be a good question for your CPA. I think yes. The opposite way is where it becomes more problematic. They're using money from the reserve fund to pay for operating costs, and that can be challenging. I mean, I think it can be done, but it's something where you typically have to pay back money, hopefully within the same year, but talk to your CPA. Question 15, we have a homeowner who built a garage without permission and did not follow the setback requirements in our association's documents. How do we handle that and without a violation schedule other than a $50 a month being out of compliance? Now they want to sell. Can we negotiate a larger fee? So we have a great blog on Quick 411 on unapproved architectural modifications that I would definitely encourage you to take a look at. We're going to be sharing that here with you today. So a couple things. I don't know on the setback, is it a city setback requirement or is it a HOA setback requirement? If it's a city one that they violated, you could report them to the city. If it's the association's setback requirement, just because our requirements are typically going to be more restrictive, I would just note on the property, on the disclosure statement when they go to sell it, that, hey, this is a violation that needs to be corrected, and the buyer and the seller are going to have to work this out. I'd also start sending letters and fining the owner for the violation. Next question, number 16. Our property management company has not been timely with emergency e-blasts, such as failing to alert us before water shut off. Our board secretary volunteered to do this. The property manager said it would be a privacy violation for him to share email addresses of owners with our board. Is that correct? I don't agree with that. I think that if the management company isn't doing it fast enough and the board wants to send it out through an email list, I'm totally fine with the board doing that. Okay, next question, 17. And I'm okay with the email addresses being shared with the board, but I would make sure it's clear that they're only supposed to be used for the intents, the purposes of dumping it into a file to send out an email blast. And if they get off the board, they should not be using those emails for any other reason. Okay, question number 17. I live in a planned community with public roads. We cannot regulate daily parking. We have a rental that is running a business from their home. Their employees park there and then leave in the work trucks. We sent a letter to the owners to no avail. Is there anything else we can do to stop the employees from parking in front of others' homes all day, every day? So you have public roads and you can't regulate daily parking on the public roads. I'm assuming that it's not in your CCNRs. The employees are parking, I'm assuming, on the public roads. We sent a letter to the owner, but the owner's not responding. I maybe check with the city to see if the owners are violating any city requirements. The employees are violating any city requirements for parking. I think that sounds like your best option because the roads are not part of the association. You're not able to regulate downstream street parking. Okay, next question. Our HOA starts their meeting with the Pledge of Allegiance. What do you think about that? I think that's great. I wish more associations were patriotic and did something like that. Number 19, we recently had a board member pass away and are left without a quorum. How do you conduct business? I think you need to put the word out there that we need another board member. In the meantime, do your best with less than a quorum to handle the affairs of the association. But you should be actively looking for a new board member to replace the deceased board member's position. And I'm very sorry for your association's loss. Okay, question 20. Can you please define recording of an HOA open meeting as a result of Senate Bill 1039? You mentioned audio and video. However, we use AI note takers that only transcribe notes so that we aren't scrambling to take notes during the meeting, as the secretary is also the treasurer. I think that AI note taker information would be considered a book and record of the association. I think that would have to be disclosed if an owner asked to see it. Question 21, should the board of an HOA provide charity gifts to SRP or other charities with HOA funds? I'm assuming that would be like kind of like a call to action in the summer, like help pay somebody else's bill who can't pay their bill. Although I am in favor of those programs helping other people, I'm not in favor of the HOA spending association money to do that. Question number 22. I'm just going to do a quick little question check to see how many we have. 42. So we're exactly at a little bit over the halfway point on the questions. Okay, can we hang a sign with a camera picture and smile as a deterrent even if we don't have cameras? I would not do that. I think that is misleading. And just so you know, we have a cheat sheet that's going out on security cameras. It's going to be released very soon, likely later this month. So stay tuned. It's going to be all about security cameras. Okay, question number 23. How can we stop a homeowner from having a garage sale every other weekend? It seems more like a business than the approved HOA twice a year garage sale. I think right there, you just kind of answered your question. We're only allowed to have a garage sale twice a year, and we've got an owner who's doing it every other weekend. So I think we just need to send them a violation letter. And if they don't comply, escalate it to the attorney. You may also be able to contact the city to see if there's any sort of a violation there with the city. Okay, next question, number 24, from somebody I haven't heard from in a very long time, but great to see you here today. What ramifications can there be if HOA community executive session information is not kept confidential and is released without board authorization by a community manager? Ooh, good question. So anything that happens in executive session needs to be confidential. It should not be disclosed to anybody, and that includes the manager and all the board members. So how do we handle it if the manager has loose lips and is talking about these things after the meeting? There needs to be like a censure by the board. And maybe we need to go to a higher up in the management company and let them know, hey, this is happening, your manager, and we're not happy about it. You need to notify the manager to stop doing it, because it's potentially putting our association in a very bad position of confidential information being released to non-board members. Okay, question number 26. Our HOA raised the fine for reckless driving in the community to $1,000. We have a part-time security team who has no training in this area. Any homeowner can report the violation and the violator will be fined $1,000. Is this policy legal? Probably not, based upon what you're telling me. I mean, you probably need to have a speed gun, or maybe you'd have to have formal training about reckless driving in order to be able to justify that, I think. Okay, question number 26. Our CCNRs specifically place the assumption of risk on the homeowner for personal injury and property damage from golf balls onto the homeowner's property. The CCNRs further state the association is not responsible for installing screening devices or trees to limit errant golf balls from causing injury or damage. Does case law support this type of CCNR language? Honestly, I'd have to do a little research and spend some time looking at that. But here's what I would say. If your CCNRs, the contract, specifically say, hey, we're not responsible for this, and if you want to install a screening device, you certainly have the right to, I think we should be on solid ground. I'd have to do more selective research on any case law from around the country, but that's my initial reaction on that. Question 27, is there a state agency or entity that we can go to force the master association to actively manage common area? Well, yes, you could go to the ADRE and file a complaint. You can file a lawsuit against the association. Those are two remedies that we talked about today. Question, or run for the board yourself. Okay, question 28. What if there's a violation that is connected with the 2-week grace period? Then the same violation is committed again and again, but always corrected within the 2-week grace period. Okay, really good question. So the trash can violation is a really good example of this. So if you have an owner that's habitual trash can person, doesn't put trash cans away, you just need to structure the violation letter, in a way that says, you're a habitual, basically, trash can person, show them the evidence, and then say, anytime you do this going forward in the next 6 months, you will be levied a fine of X dollars. And this is your notice and opportunity to be heard, so that they realize that they can't play the 2-week grace period game anymore. Question 29, what do you suggest as the schedule for the various letters? So for this friendly reminder letter, it just depends on what the violation is, because some violations take longer to correct, but I would say 10 days, would be a good respondent or correct within 10 days for the first violation letter. For the second one, probably 30 days. Question 30, is it legal to send a courtesy notice and then fine the owner for a second violation within 90 days after the owner corrected the violation and documented it upon receiving the courtesy notice, whether the fine was not stated on the courtesy notice and the fine letter said it was? Again, this is kind of the exact same example I just gave you. The letter has to set it up correctly. It doesn't sound like the letter that was sent, second courtesy notice or the second violation notice, set it up right. So you can't just go right to fines, right? The statute says you got to give notice the violation, opportunity to be heard, and then fine. Okay, next question, number 31, requesting enforcement of violations and the member's right to hearing before fines are imposed. Does the same process apply when the amenity access is revoked? Our CC&Rs require an initial warning before issuing fines, but this step has not been applied when restricting amenity use. Could we be in error by revoking access without following the fine schedule? No, I don't think so, because revoking privileges used an amenity are not a fine. A fine is a monetary amount. So I would just say, I don't know what your sections say about revoking the ability to use something for a violation or due to a violation, but that would have to be followed. I don't think that you have to have, you don't have to follow state law regarding fines, but you would have what you have to do before you can revoke. Okay, question 32. Our violation fine process provides courtesy letter. Then if it's not remediated, a second or third letter after 2+ weeks, although the property manager may not get around to issuing the second or third letter. Is it a good practice to have these time-based fines in addition to a standard fine list, depending on the violation? Time-based makes sense for violations like weeds in a yard, may only take a week or so to schedule a service, but not for things like parking violation or pet waste, as those are a single instance. It doesn't take 2 weeks to remove a car or pick up pest waste. We are considering adding a list of standard fines to our enforcement policy. So the question is it good practice to have time-based fines in addition to the standard fine list? Probably what I would do is just have like a catch-all phrase in your, violation and fine process that just says the board can deviate from this if the violation can be cured quickly or it's a health and safety issue, and this fine process is a guide, but the board can deviate it from whenever it's needs to, basically. Okay, question 33. If a homeowner adds tile to their front walkway, which is a limited common area, and they slip and fall, is that the HOA insurance or homeowner's insurance liability? A limited common area is still a common area. It just depends. Probably both. Claims will probably be made on both. If it's the walkway and no one else has access to it, it's possible it will just be the homeowner's liability policy, but if it's a walkway that other people can cross over to, it probably is going to be a claim on the association. Well, 34, what are some options when a homeowner refuses to accept communications, such as demand letters via U.S. Postal Service? Well, like I said earlier, I'm not a big fan of sending things by certified mail because they just never go and pick it up and sign for it. So I am a fan of sending it by U.S. mail. You could also post it on their door. You could also email it to them. Once it's in the mailbox rule says once the association mails it and it's the correct address, it's considered received. So within however many days later. So if a homeowner refuses to accept communication, I would still continue to send them things by U.S. mail because it is a valid way to communicate with them that's legally recognized by courts. I'd post it on their property and I'd also email it to them. Just set it to every possible way. I'd also pick up the phone and be like, hey, why aren't you responding? Or why is this violation still existing? Okay, question 35. Do ADRE judgments have the same enforcement ability as lawsuits? So generally speaking, no. It's just a piece of paper saying X violated the documents or X violated state law, and it really doesn't give us any subpoena power or ability to hold them in contempt. Okay, question 36. Our HOA board is still under the builder, which will transfer the homeowners within the next 9 months. Our development is 6 years old, and we still have not been provided a violation and fine policy. Who is responsible for the homeowners to receive this policy, or what is responsible? They're not required to have a policy. a fine and violation policy. So, you can ask them if they're considering it, but they're not required to have one and they may not have one. If they do have one, just make a records request to see it. Okay, question number 37. Do our documents have to be very specific about violations and the fields we can change, or will a general reasonable fees work? I prefer fine policies that are more open-ended and aren't so boxed in, this for this, that for that, X for this, second notice. I'd prefer having a more fluid one where the board can just levy reasonable fines. Question 38. Are there Arizona laws that dictate good standing to run as a board member? No, there aren't. You need to look at your bylaws. Typically, you have to be an owner. And typically, unless it says that you have to be current on your assessments or no violations, typically it's not a good thing, but you can't disqualify them for that unless it's in your documents saying they can't be delinquent or whatever to serve as a board member. Question 39. Can an HOA use surplus funds from the previous year along with some reserve funds to pay for a capital project? Check with your CPA, but I'm not opposed to that as long as the minutes reflect what's being done. Okay, next question, number 40. My understanding is that due to recent legislation, HOAs with governing documents recorded after 2015 no longer have the authority to enforce parking rules on public streets regardless of the documents, as many cities have restricted that authority. Could you please clarify how this impacts a community's ability to regulate street parking? A couple things. This is kind of a loaded question. This law that did just go into effect last year, it's complicated. It applies only to planned communities, and it applies only to planned communities where the streets are public streets. And so I don't know if your association is one of those associations or not. Go to our blogs on our website. We have a lot of articles on this that I think would be helpful to you as you navigate answering this question. So question number 41, what is the process to overturn an ADRE decision versus traditional court litigation? Actually, really kind of interesting. So if you don't like a decision that's made by an ADRE judge, you can appeal it to Superior Court. If you don't like a decision that's made by a Superior Court judge, you can appeal it to the Court of Appeals in Arizona. A couple things, if the ADRE decision, once you appeal it to Superior Court, they make the final decision and it's over. In a traditional court litigation, you can keep appealing it. So if you don't like your trial court judgment, you can appeal that to the Court of Appeals. If you don't like that, you can appeal that to the Supreme Court of Arizona, et cetera, et cetera, et cetera. Okay, last question for today. Does just the courtesy letter have to give the opportunity to appeal or vary violation letter that follows for the same violation? This gives homeowner the opportunity to appeal every letter. So does the courtesy letter have to set up the fine with the opportunity to appeal? Apparently your association keeps giving the opportunity to appeal on each letter, and that's probably not needed. The only time that you give them the opportunity to be heard is when you say, hey, I'm going to levy the fine of X, and you have an opportunity to be heard. If you set the letter up right, if it's going to be a repeat fine, you got to set the letter up right saying, hey, we're going to fine you $100 a month for every month that you don't have the lot in compliance with landscaping. And here's your notice of opportunity. Here's your notice of opportunity to be heard. Respond to us within 30 days or 10 days or whatever. And so really just the letter where you're setting the fine up has to have that opportunity for notice and opportunity to be heard due process. And that could be in any of the letters, depending on where you're setting up the fines. Okay, so we had a great day today. We got through 42 questions, which is a new record for 2025. So that's great. And we got through them in about little over 34 minutes. So that's amazing. We also had today a new record as well. We had live 220 people listening to us on Zoom or Facebook Live at our peak today. So that is also a new record for 2025. So 220 viewers at peak and 42 questions. Amazing. Thank you so much for being here. I know it's so hot out right now, but maybe a great time to be listening in on these classes, right? Okay, let's talk about what our upcoming classes are so that you're aware of our next free opportunities for you to learn more about association law. So we have our first Fridays in August, and that is going to be August 1st at 9 a.m. And it's, of course, going to be live on Zoom, just like it always is. You can get more information by going to our website to submit a question, and we just hop online on Friday, August 1st at 9 a.m., and I'll be answering questions rapid fire. We also have a class in August. It's class number 8 on Tuesday, August 19th from 11 a.m. to 12 p.m. on Zoom and Facebook Live. And we're going to be talking about mastering HOA and condominium finances. And we're going to be talking about what do you need to do to create the 2026 budget for your association? How do we read financial statements? What are our board members' fiduciary responsibilities? And how do we understand reserve studies and reserve accounts? And that's going to be a great class on Tuesday, August 19th. I'm going to be having Hayden DiLorenzo and Madeline Gegg from my office are going to be teaching that class for me because I'm going to be moving my son into college. I cannot believe it, but I am sending him off and we are moving in that morning. And so I won't be there for that class. So you will have it all set up and it's going to be a great class with Madeline and Hayden, but I won't be there that day. Lastly, before we sign off today, let's consider liking us on Facebook and following us on LinkedIn or Instagram, just so that you can stay up to date on what's going on in the HOA and condo industry in Arizona. So consider liking us on our Facebook page. We're very active, putting a lot of information on Facebook, LinkedIn, and Instagram. Great resource for you to have pop up on your screen just to let you know about important things that are happening. Lastly, if you wouldn't mind, we would genuinely appreciate it if you would consider giving us a Google review or a Yelp review today for attending the class. We need to get feedback to the different cities that we teach these classes for, so it's very helpful if you don't mind doing a quick Google review or a Yelp review as to whether or not you like these classes and do you find them helpful, and anything that you'd like to say about our firm would be very, very much appreciated. We also have a Facebook link as well. So LinkedIn, you can give us a review on Facebook. You can give us a review on Google, which is preferred, or Yelp, which is preferred. And I would very much appreciate that. Okay, everybody, have a great rest of July. Can't wait to see you again on August 1st for our first Fridays, and enjoy the warm weather. And thank you for everything that you're doing to make your associations better. We appreciate you. Take care, everybody.
Don't forget, our free cheat sheets are available for download at mulcahylawfirm.com.
The intent of our Zoom, Facebook Live, First Friday free call-in, videos, and podcast is to provide a forum for board members and community managers to receive answers to HOA and condo legal questions. Please note, the content of these sessions are general in nature and is not intended to and should not be relied upon or construed as legal opinion or legal advice regarding any specific issue or factual circumstance. You should directly consult with an attorney for advice regarding your individual situation.